Hey guys, TheRealLauraB here. I just had a live chat, a live stream about Amber Heard's latest interview. And while we were streaming, somebody commented asking about the ACLU versus debt or debt versus ACLU actually to get them to pay the $86,000 in expenses they want Johnny to pay. And they filed their motion. Johnny filed his opposition. I made a video on this, part one. And ACL now just filed their reply to his opposition. So I thought I would just cut that in here, if you don't mind, rather than me reading it again. So hang tight and be right there. Hi, I'm Laura, also known as TheRealLauraB from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. And I'm going to splice it right here. So I just saw a question, and I'm going to check this to see if there is an update in the ACLU case. It takes me a little bit to get to it, and then I've got to track it here.
Did it just come out now? Is it new?
It just got uploaded, yeah.
Oh.
So let's see if I can
So exclusive.
Yeah, got exclusive. If it lets me in, come on, let me in. Keeps having me do the CAPTCHA.
Oh God, I hate that.
Oh. Try again. View my cases. Click on there. Click on show file document. So what's happened is they filed for the $86,000. Depp's team opposed it, and now they're coming in with they get to reply their opposition.
Ooh.
So okay. Yeah, who asked me this? I'm sure you've gone. Somebody asked, "Is there any updates?" See, I think you flew past me, but let's see if I can share this. So you're getting a breaking news here.
Breaking news exclusive, guys.
Yeah. Well, I even found it pretty fast. How does this work? Yay. How it's big enough for you to read.
Yep.
I can go a little bit bigger. Let me make sure it's on my screen. So this is ACLU's answer to the opposition that Depp filed. So, and there's going to be a lot of legal cases that we will not read. ACL, I can go a little bit bigger so I can read it. I can't go quite that high. The ACL non-parties respectfully submit this reply memorandum of law in further support of their motion for production of expenses, and they want the full amount, which are incurred in complying with the 3 non-party subpoenas and the document one. Mr. Depp does not dispute that New York law requires him to pay. He said that. They want, and the cost, they want all the cost of the legal fees, which was about $86,000 in order to comply, and expenses in collecting and identifying production documents, which was about $1,000. The bulk of that amount was incurred after Mr. Depp rejected several compromise proposals that would have reduced the ACL parties' compliance costs. Well, yeah, sure, but they tried to squash this, and the judge said, no, you have to do all this. These are the subpoenas. You have to do all of this. Now faced with monetary consequence of serving broad discovery requests on a non-party, Mr. Depp argues that the ACLU non-parties, they're going to keep driving that home. We know you're a non-party.
Seriously.
We know he didn't sue you. Are not entitled to recover costs of attorney review necessary to identify documents responsive to his subpoena. That argument makes little sense in the context of modern electronic discovery. And unsurprisingly, it's not supported by New York case law. Mr. Depp is equally off the mark in arguing that the ACLU assertion of privilege and work product protection over a small number of documents waives the mandatory obligation to defray the costs. New York case law does not support that proposition either, which would put non-parties to the Hobbesian choice of either waiving attorney-client privilege or being forced to bear the costs. And they cite their case. Mr. Depp puts forward no support for his position that the rates or the number of hours worked by ACLU were excessive. Well, they did say that they felt that the rates were excessive. They thought they were not reasonable.
Yeah.
And that's what they're saying. They're willing to pay reasonable costs that the judge will decide. he argues warrant denying or reducing the fees expenses requested, the court should grant the motion for the full amount. ACL parties are entitled to recover attorney's fees under the New York law. So they're going to cite other cases. Mr. Depp does not dispute that the New York law provides for the reimbursement of reasonable production expenses to a non-party. But he goes on to argue that the attorney review time and associated fees were not reasonably required to determine which documents were responsive. They're saying he's misstating the law, where attorney's fees are directly related to preparing a document production in response to a subpoena. That's the documents.
Yeah.
They must be reimbursed by the requesting party. Multiple authorities in New York, including recent authorities that Depp ignores, support the common sense reading of the rule. They cited all their docs or their law cases to support their decision. Although Mr. Depp maintains the attorney fees for time spent on responsiveness and privilege review are not recoverable, the authorities he cites are non-binding, unpersuasive, and have been disapproved by courts that have considered the issues more recently. So again, they're coming up with more cases.
Yeah.
The court declined to award attorney fees arising out of a motion to quash subpoena memorandum of law. They're claiming they're not asking for those. Mr. Depp attempts to distinguish several cases cited by the ACLU non-parties because the court determined that it could award a non-party attorney's fees, but declined to do so until the non-party substantiated the fees or until the parties met and conferred. That's part of what Depp said too. They're not reasonable. Contrary to Mr. Depp's suggestion, this is the case he cited, does not stand for the blanket proposition that an award of attorney fees or non-party is unwarranted whenever the non-party has some association with the underlying case. In this case, for instance, the court awarded attorney's fees for attorney review, notwithstanding the petitioner's allegation that the non-party was intimately involved with defendants in the underlying case. So they're not a party. They're not, we'll see. Moreover, the ACL non-parties did have substantial rights at stake in ensuring that only responsive, non-privileged documents were turned over, including preserving the privacy and First Amendment protected association rights of donors who had no relationship with the underlying litigation between Mr. Depp and Ms. Heard. So I guess they're claiming in these documents they searched, other donors came up, so that's why they had to review them. So they had a review for production and for privilege and relevancy. Other donors would not be relevant. They do not provide a practicable rule because it is unclear whether time spent reviewing documents for production could be broken down into review for privilege and relevancy versus other purposes. That is certainly the case here, where the ACLU non-parties, in an effort to review efficiently, had only one attorney look at each document for purposes of determining both responsiveness and privilege, and did not withhold documents based on relevance at all. Because reviewing for responsiveness was necessary to comply with the subpoenas and produce documents to Mr. Depp, it's recoverable expense of production. Mr. Depp is equally misguided to suggest that time reviewing for privilege work product and preparing a privilege log is not recoverable. Indeed, the subpoenas themselves demanded that for every claim of privilege, the ACLU specify in detail each and every ground on which such claim rests, and ideally generally what the document is. Furnish a privilege log, can't talk, that includes a statement of the specific privilege claimed and the basis upon such privilege is claimed, and they're quoting from the subpoena, as to each separate document or portion withheld. So this was part of the subpoena they're claiming.
Yeah.
That a privilege log had to be provided and categorized. He cannot make a demand for such a time-sensitive task and be surprised when it dramatically increases the legal fees. It would not be reasonable to require a non-party to produce a privilege log at its expense or waive the privilege. The ACL non-parties disputed and continue to dispute the relevance of the documents sought by Mr. Depp. And that was in their motion to compel. But the ACLU non-parties did not withhold any documents based on their irrelevance. They produced any document that hit on the search terms and responsive to Mr. Depp's request, unless subject to a claim of privilege. Nor should Mr. Depp be surprised by the volume of privileged communications when his subpoena included a request for ACLU communications about the underlying litigation itself. So apparently it was a very broad request they're claiming. Mr. Depp fails to establish that the ACLU cannot recover for attorney's fees reasonably incurred in responding to his broad and burdensome subpoenas. But the judge found for Johnny in all of these.
Yeah, she did.
You have to remember, when I read these things, these are allegations. This is what they hope is going to happen. They can pretty much say
Yes,
anything they want. What actually matters is what the judge decides. So right
exactly.
now, they're just arguing back and forth. The amounts requested by ACLU reflect reasonable rates and reasonable hours as supported by detailed backup. Counsel's hourly rates are reasonable. Mr. Depp cites nothing but his own conclusory and self-serving assessments to dispute the reasonableness of counsel's rates. A reasonable hourly rate is based on the customary fee charged by similar services by lawyers in the community with like experience and of comparable reputation. I'm not sure they had to have the very top lawyers do this, but
I was going to say that now. I was thinking that.
reasonable hourly rate is based on what a reasonable paying client would be willing to pay, given that such a party wishes to spend the minimum necessary to litigate the case effectively. Mr. Depp's disagreement with the ACLU's privilege and work product assertions is not relevant to the ACL non-parties' entitlement for reimbursement. Mr. Depp agrees that they're entitled to something. ACL responded in writing to Mr. Depp's objections to privilege assertions in last November of 2021, over a year ago, providing the basis and legal citations supporting the privilege assertions. Mr. Depp's counsel never responded. See, there's always two sides, but then there's going to be the truth in the middle.
Exactly. That's where the judge comes in.
Yeah. Mr. Depp does not cite anything in support of his bald assertion that counsel's rates are above market. Moreover, the ACL non-parties reduced the total cost by using a junior associate to perform the majority of the review, supervised by a senior associate, without requesting reimbursement for any partner time at all. Mr. Depp raises no dispute at all with the reasonable rates billed by technical staff employed by counsel to collect, process, and produce documents. The number of hours worked is reasonable. Mr. Depp contends that the number of hours spent by outside counsel's attorneys is responding to the document subpoenas was unreasonable, but again fails to provide any legal or factual support for his claim. As detailed in the ACLU opening brief, in light of the broad scope of Mr. Depp's request and refusal to entertain more cost-efficient compromise proposals, the hours required by outside counsel to comply was reasonable. So, if you find the hours are reasonable, the breadth of subpoena demands and failure to reach an agreement are reducing the scope of the subpoenas. The hours expended are supported by detailed billing. Mr. Depp does not challenge that. Counsel's costs are reasonable. Mr. Depp does not dispute the reasonableness of ACLU's request for reimbursement, and this is the document cost incurred in the monthly data hosting fees. Conclusion: for the foregoing reasons given, the ACLU moving brief, the court should grant the motion to pay them the total. So that's that. That's done. So we've got all filings done. Now we're just going to wait for the judge's decision. That'll be on June 15th is the hearing. I'm not sure if they're going to have an in-person hearing. It may just be document. They could be doing it a WebEx hearing, but then he'll have a ruling shortly after that.